So there will be an increase in the minimum wage from April 2022. This was announced in October's budget. The headline is the national living wage, which applies to those aged 23 and over, will go up by 6.6% to increase to £9.50 an hour. So just beware that the minimum wage applies to those who are paid by the hour as well as those who are salaried. So for example, somebody working 37.5 hours, they'll have to be earning a salary of at least £18,525 to be minimum wage compliant. And if your organisation employs people at or around the minimum wage and who will benefit from this increase, don't just think about those who are on the minimum wage, but think about the next pay grade up as well. Do they need to have a pay increase to maintain that differential between the bottom grade and the next grade up? So we're all in for an extra bank holiday this year. We've got the Queen's Platinum Jubilee on Friday the 3rd of June. And the normal late May bank holiday has been moved to Thursday the 2nd of June, so potentially creating a 4-day weekend for those whose workplace is closed on bank holidays. So for some employees, they may get an extra day off this year. For others, it might have to come out of their existing holiday allowance. So our message for employers is to check your contracts first to see how this extra bank holiday is going to be dealt with. A typical example of how a holiday allowance might be expressed in the employment contract might be that it says X number of days plus bank holidays. In that instance, the employee will be entitled to take an extra day off this year on the extra bank holiday. If the contract might say X number of days holiday including bank holidays, then the employee will have to take the extra bank holiday out of their normal annual holiday allowance, so they don't get an extra day off this year. A more well-drafted contract might say X number of days of holiday plus the usual 8 bank holidays. So you can probably see what the employers tried to do there. They've tried to cater for a situation where there are extra bank holidays, and this will mean the employee's got to take it out of their usual allowance. And this might sound familiar. If you think back to 2011, we were in a similar situation where we had an extra bank holiday for Prince William and Catherine's marriage. So it may well be worth looking through your archive to see what your organisation did in 2011, as you may well have set a precedent for how to treat the extra bank holiday this year. Currently, all employees who've worked for their employer for 26 weeks or more have the right to request to work flexibly. Flexible working could mean lots of different things, including working less hours, working part-time, working more longer hours on less days, or an element of home working. Clearly, during the pandemic, people and organisations have had to work more flexibly, and we are seeing lots more inquiries now about flexible working requests where there are employees who are complaining that their employers have not accommodated their requests. Now, the government's picked up on this, and they propose to remove that 26-week qualifying period, so a new recruit from day one could potentially make a request to work flexibly. Now this is only a request to work flexibly, and employers can still turn down the requests where 1 or more of 8 prescribed reasons apply. But employees are more aware of their right to request and their ability to challenge any request that's turned down in an employment tribunal by way of a claim, in some cases involving discrimination as well. So our message for employers is that if you are unable to accommodate a request, make sure you can fit it in one of those 8 prescribed reasons, and also think about how, ideally with evidence, you would justify the commercial rationale for turning down any requests. So there are millions of working unpaid carers who have to juggle caring responsibilities and jobs. And under this proposal, working carers will be entitled to take up to 5 working days a year off work, unpaid, in order to help them carry out their caring responsibilities. It can be taken as a week off, or in individual days, or in elements no smaller than half days. And this is to help promote a good balance between family and professional commitments, and provide more equal opportunities for men and women to take on caring responsibilities and juggle those with working responsibilities. Now, the intention behind the policy is that this is designed for caring for those who are relatives or live with the employee and who have long-term caring conditions. But employees will be able to self-certify that they meet the conditions for taking this carer's leave. And whilst this may leave the right open to some abuse, the concern was that to require otherwise would mean employees disclosing sensitive medical information about the person they're caring for to their employer, which was deemed to be unsatisfactory for a number of reasons. This is expected to be introduced in an employment bill, which we hope will be introduced during 2022.